Welcome to the Rise of Legal Review for Cloud-Based Legal Documents webinar. I'm going to welcome today's moderator into the conversation. Welcome, Kristen Beadle.
Thank you very much, and welcome to today's sponsored webinar, The Rise of Legal Review for Cloud-Based Legal Documents, sponsored by NowInfinity and hosted by CPA Australia. My name is Kristen Beadle, and I am the Manager of Public Practice and SME, Professional Standards and Business Support at CPA Australia. We have people joining us from all over the country today, so thank you very much for attending today's webinar. Before we start, I'd like to take a moment to acknowledge the traditional owners from around Australia and pay my respect to elders past, present and emerging. I extend this acknowledgement to all Aboriginal and Torres Strait Islander people who will be joining us today. Now it's my pleasure, it's now my pleasure to invite William So to present today's webinar. Thank you, William.
Good afternoon. Thank you for joining us today. I'd just like to take this opportunity to thank CPA, Class and NowInfinity for asking me to speak to you today. So just a quick introduction about myself. So my name is William. I was admitted to the Supreme Court of New South Wales in 2008, and I joined DGF Morgan and Associates in July 2012. Since then, I've advised on company and property transactions, trusts, super funds, and corporate matters, including converting company types, reclassifying and varying rights attaching to shares in the company. I've also seen where things go wrong for clients and assisted in rectifying these issues, sometimes when professional advisors have ordered documents from a cloud-based service without obtaining a legal review. One of the biggest ones I acted on included a LRBA issue, and that had stamp duty issues and SMSF compliance issues as well. And if we do have time, we'll go into that later. In terms of our experience with document providers, the principals of this firm, David Morgan, co-founded a document provider back in 1979. And for the past few years, I've been involved with the drafting of legal pro forma documents. We're now partnered with NowInfinity and Class, providing legal reviews on their documents for their users. So our experience in drafting documents and advising clients is quite extensive. So document providers, as I've mentioned, have been around for many years now. Just as a quick note here, I will be using sort of document providers and cloud-based servers interchangeably during the webinar today. So back around the 1980s, it would probably take about 6 weeks to register a company, and that delay in registration fueled the demand for shelf companies, which were companies incorporated with nondescript names and temporary shareholders. The office holders resigned and shares were transferred when the shelf companies were sold to the accountants purchasing companies for their clients. Over time, that incorporation were done over the phone and then later by fax. Nowadays, as I'm sure most of you know, we're able to lodge almost instantaneously with ASIC via a document provider. These cloud-based services over the years then also started offering other types of documents that were typically legal documents, so establishment of discretionary trust and unit trust, as well as superannuation funds and also other commercial documents. It's been a very challenging few years, and a lot of us have had to adapt in order to be able to work. One of the biggest changes a lot of us have had to deal with is adapting to working from home and being able to access files from the office without actually physically being there. Notwithstanding that, obtaining documents from a cloud-based service has become quite easy. Most people have access to these cloud-based services that work almost 24 hours a day, and you could access them from almost any computer with internet access. And that sort of access has given a lot of us flexibility, especially with all the lockdowns that we've been experiencing the past few years. Adding a legal review option to cloud-based services only increases the availability of legal providers to users of those cloud-based services. And as the accounting and legal industries move more and more towards a cloud-based flexible working solution, cloud-based document providers and law firms need to adapt to meet those challenges. So before I move into what is legal review, it's important to note that most documents obtained from cloud-based services are based on standardized templates, usually drafted by lawyers. So no one document will suit every client's needs. Having said that, a majority of clients may simply just use these documents without issue. However, there are some clients that may have certain concerns about things. So for example, you might have a client who went through a very messy divorce and wants to make sure that their ex-spouse is not a beneficiary. Or there might be some succession issues if they or your client is the sole individual appointer, or even the sole director of a company, or there might be financing issues, such as the bank wants a personal guarantee from each named beneficiary of the trust. So a legal review is the process of having a lawyer consider the documents obtained from the cloud-based service after the customer completes the relevant data in order to confirm that those documents either complies with the relevant powers of an existing deed to make a change, or to have a standardized template amended to suit the situation specified to that client, or to ask specific questions of those lawyers who have drafted or are familiar with the standardized templates. So what are the risks of not getting a legal review? One of the biggest risks of purchasing documents is not taking into account whether the document is suitable to your client's particular circumstances. So for example, if we go back to our client who has gone through a messy divorce, they might be wanting to set up a discretionary trustee, and they want to make sure that the ex-spouse is not a beneficiary. Now, a cursory glance at the discretionary trust deed might reveal that the beneficiary includes spouses of the named beneficiary. You and the client might think that's okay, because now that they're divorced, they're no longer a spouse. However, some trust deeds are drafted to define spouse as a spouse, a de facto spouse, and includes a former spouse or former de facto spouse. So in those cases, you may want to get a legal review to get specific legal advice, to have that minor amendment made to the standardized templates in order to ensure that you've mitigated the risk if the client comes back and says something went wrong. Many clients in a divorce aren't satisfied with merely deleting the ex-spouse's name as a beneficiary, and they may also want to see them irrevocably excluded for all time. I've been focusing a lot on establishment documents. However, some cloud-based services now provide what were traditionally legal documents that affected a change to the existing entity. For example, transfer of shares, appointment of directors and secretaries of a company, changes to trust deeds, and trust deed variations. It's important to remember what I said at the beginning of this slide, that is, documents obtained from the cloud-based service are based on standardized templates. So like tax returns, without changes or questions being asked, not every document off the shelf will suit everyone. Without input from a lawyer with relevant experience, there may be a risk that the documentation you obtain may not be suitable or may not be legally effective. Problems, and if there are any problems, they only come to light when there's a dispute, or if the client changes accountants, or goes to a lawyer to get some other changes done. So now that I've just gone through very quickly what a legal review is, Michael, if I could just ask you to open the polls for this slide. So we've just got 3 quick questions here. So we'd just like to know whether or not you've obtained a legal review on legal documents that you've obtained in the past. What do you see the biggest challenges when it comes to legal review? And just so I can do a quick comparison between now and the end of the webinar today, what reason best describes why you registered for the webinar?
While everyone's having a think about these questions, William, do you have any any war stories that you might be able to share just really quickly with our members on what happens when it didn't happen and you didn't get that review?
Yeah, I've got a case study that we will go through, Kristen, which sets out probably one of the sort of big war stories that we've got. We did have a matter with a super fund that I sort of alluded to earlier, where an accountant just bought an off-the-shelf bare trust holding trust for a super fund because it was purchasing property and it was borrowing to purchase that property. And there was just no communication between the accountants, the client, and the solicitor who was acting on the transaction. And that resulted essentially in that super fund being non-compliant for a couple of years because they didn't comply with Section 67A of the SIS Act. A legal review probably would have solved that because we probably would have just said to them, speak to the solicitor acting on the purchase because you just need that clarity because otherwise, I think it was actually also a related party loan. And so the accountants thought that, yep, that's the right thing. We'll set up a holding trust for you. The client then sort of turned around and didn't say anything to that solicitor acting on the purchase. And so ended up having this property being transferred directly to the trustee of the super fund instead of the custodian trust or the holding trust, and just went along and nothing happened until she tried to get the loan refinanced. And that's when the bank said, well, that's not compliant.
Yeah. Wow. Okay, I see that your poll results have come in, so I'll
Thank you, Kristen.
Thank you.
So see, almost half of you have not obtained legal review before, and that's all right. But I think a lot of people say, 49% sort of say that one of the biggest challenges is the cost of the legal review. And I'm probably a split between not having heard of legal review with document providers before and hesitant to use legal review because you just don't know how you benefits. So hopefully we will see how that goes. And sorry, Michael, I can't seem to actually be able to change slides.
All good. I'll steal control from you and give it back to you, and that should trigger it.
Thank you.
And there we go. Do you want to try now?
There we go. Excellent. Thank you. So when is legal review applicable? Well, I'm a lawyer, so I will say always. But I do recognise that there are some times when it is not appropriate. So it is a choice for the user when ordering documents and for the user to assess the risk of not getting a legal review. It'd be a good opportunity to take advantage of legal review to minimise your risk when ordering documents off the shelf. So there are many variety of documents, and as I said earlier, what is suitable for one client might not be suitable for others. It gives users the opportunity to have the document reviewed by a lawyer and your specific question answered, or if your client has a particular question of the documents that they're ordering, those can be answered as well. I've put a few examples on this slide of some war stories. So you may want to get some amendments made to standardise legal templates to better address your client's instructions and circumstances before they execute the deed. They may want to have restrictions made to the classes of beneficiaries, or they may want to provide for successors of an office or an officer. So, for example, like I said before, a sole director of a company may want to try and provide for a certain person to be appointed after their death or some sort of mental incapacity. The other times when legal review are applicable is when an entity has already been established and legal changes are required. So there might be a change of trustee or a change of appointer or a variation to a trust deed where the deed's quite old, or a super fund deed where that's quite old and hasn't been updated for some time. The two examples that I've got here, I haven't really touched on yet, but these are more situations that apply after documents have been signed, and there have been situations where a third party, for example, a bank, raised an issue with the legal effectiveness of documents, and they include deeds not being witnessed. We recently had one where a deed wasn't signed by the settlor, so as the discretionary trustee wasn't signed by a settlor, or if documents are executed by companies that didn't comply with Section 127 of the Corporations Act. You may also see that you need to review just to make sure that all the documents prior are legally effective. So there might have been a change of trustee at some point, and you're just not sure whether or not that was legally effective. Now, I'll just take a moment here just to say that nothing in today's webinar constitutes legal advice. However, when a legal review comes in, one of the main things that I say to my paralegals when they're initially doing some preliminary work is to ask themselves the following questions. So what is the client trying to achieve? Is there power to do so in the rules that govern the entity? So the trust deed, the governing rules, the unit trust deed, or the company constitution, and if there's no company constitution, then the Corporations Act. Who can exercise this power? How can they exercise this power? Are there restrictions on that exercise of the power? And does anyone need to consent? And of course, I'll say to them, as I'll say to you now, if you're ever unsure of any of those answers, take it straight to a lawyer. It might be that there is no way around a restriction to the power, or it might be one of those really old deeds where the sentence runs as long as the page, and the more you read it, the more it stops making sense because there are so many provisos in it. I certainly know I've seen my fair share of those. It's not the first time I'll say it, and it's certainly not going to be the last time I say it. If you are unsure, take it to a lawyer. So over the years, I've acted on a number of matters where documents contain errors and appear not to be legally effective. Now, I'm not suggesting that all these examples were obtained from cloud-based servers, but in the past few months, I've seen these from accountants who have ordered legal review on documents obtained from these types of providers. So it still surprises me the number of times I've seen documents prepared where trustees purport to appoint a new trustee when they don't have the power. Usually it is an appointer or the unit holders who have this power. Lately, we've reviewed a number of self-managed super fund deeds that require the consent of founders and guardians, and those roles haven't been seen in super fund deeds for many years now. They haven't been included in modern super fund deeds for many years now. And it's important to know who needs to consent, because if the right parties don't consent, there's a potentially legally ineffective variation, as it wouldn't comply with the existing governing rules of the fund. Incorrect ACNs and typographical errors in company names are another common example of when things go wrong. However, nowadays, most document providers have a direct link to the ASIC database, so these errors almost get picked up, almost. instantaneously. However, there are still some manual entering of data, and that's where human error occurs or can occur. And often these need to get rectified urgently because there are looming finance and or property purchase deadlines. I've got two other examples that haven't made their way to the slides, unfortunately. But middle names of individuals can be omitted, and that's understandable because you may know your client as John Smith, but their driver's license or their passports might show their name as John David Smith. With more and more scrutiny by banks, these omissions are picked up when the clients are trying to open bank accounts. So it might be a good idea to ask for identification documents that a bank would ask for, just to minimise those middle name omissions. And I've recently provided a legal review on a SMSF deed update where the variation power was so old, it provided that no variation to the governing rules could have the effect of permitting any trustee to be other than a constitutional corporation. It meant that had the accountant relied on the document that was based on a standardised template, that variation may very well have been completely ineffective as the rules repealed and adopted a new set of rules. So that adoption had the effect of permitting the trustees to be individuals if the sole or primary purpose of the fund was to provide old age pensions, which is a very standard term. And while you are allowed to have individual trustees because of Section 17A of the SIS Act, that variation was in direct conflict with restrictions on that variation power. So that could have been another example where something could have gone wrong there. Michael, I'll just very quickly just ask you just to open up the poll for this slide as well. So, sorry, I'll just take a quick sip of water, sorry. So, apart from that last example, do you think any of those situations could be rectified?
Just to let you know that the polls are completely anonymous, so do go ahead, click a response and click submit. At the end of the poll, you will need to click the chat icon to bring the chat box back. So I see there's about 150 people who have not started the poll, so please do go ahead and click a response. Thanks.
Should be right to keep going, William.
Yeah, sorry, I did get distracted because I saw a question come through and I was trying to work, just trying to see if I could work out an answer. So in most cases, yes, these can be rectified. But of course, as a lawyer, I do have to say there are some exceptions, but in the majority of cases, they can be rectified. Okay, right, perfect. Okay, so this is one of the matters that we're currently dealing with at the moment. So let's take a few minutes just to go through this case study. So let's imagine that Mrs. Doe has walked in and said that she wants to amend a unit trust deed. Now, Mrs. Doe says that Company A is the trustee of the unit trust and that she's the sole director, secretary, and shareholder of the company. So on a preliminary view of the trust deed, we see that the trustee has the power to amend. There's no consent required. The restrictions on the exercise of the amendment power are irrelevant to the amendments we are making. And no, that's all. Sorry, I thought there was another one, but there wasn't. Sounds great so far. So we then look to the schedule to the trust deed and we see that Mr. Smith is the trustee of the trust. So we turn around and we say, oh, I'm so sorry, Mrs. Doe, but who is Mr. Smith? And she says, "Oh, Mr. Smith, I haven't spoken to him for about 10 years now. He was my former accountant. Uh, why is that important?" And we will say, "Well, no, sorry, Mr. Smith. It looks like Mrs. Doe. It looks like Mr. Smith is the trustee, not Company A." And Mrs. Doe says that Mr. Smith obtained some document from a document provider and he signed it, and that appointed Company A as the trustee. And she hands that document to you, or to me, sorry, because I'm the lawyer. Sorry, Mark, I'll just get you to open up this poll here as well. So let's just get a quick understanding of what we're thinking here. Do we think this appointment of Company A as trustee was effective? So we've got our options. Yes, definitely. The trustee has the power to do anything related to the trust. No, because the unit holders are the ultimate owners of the assets in a unit trust, so they need to do the appointment. Or our third option, that I haven't given you all the relevant information yet. Okay, so I see some of you, about 40%, have answered either yes or no in that. And just for those people who answered yes or no, I'll go back to those initial questions that I would usually ask the paralegals to consider. Is there power to change the trustee? Who can exercise that power? How can they exercise that power? Are there restrictions on that exercise of power? And does anyone need to consent? At the moment, we haven't actually reviewed that clause of the trustees yet. So I haven't actually given you all that relevant information yet. Unit holders do often have that power to change trustees. However, that can't be assumed that that's the case in every situation. So now we have this document that purports to attempt to appoint Company A as the trustee. So we now have to go and have a look at to see if there is power to change trustee. So looking further into the deed, we see that there was the office of the appointer who has the power to change trustee. There was no consent required, and they had to do this by executing a deed. Now, the rest of the other sort of questions that I would usually ask are irrelevant because there was no appointer. There was no position of the appointer, and it wasn't filled. If you looked in the schedule, there was no appointer listed. If you looked in the definition section, there was no appointer definition, and there was no other provision in the deed that actually referenced the appointer. So there was no actual power for anyone to appoint an appointer. Although if there was such a provision, it was likely that the appointer had that power, although there is no appointer. So it was very likely that it was just a drafting issue in the original trust deed. So we're at the point where we have an ineffective appointment of Company A as trustee of the unit trust, and no way to nominate an appointer to rectify that ineffective appointment. So our legal team are getting together, and we've come up with some suggestions as to what our next steps would be. So just moving on to the next slide. Sorry, Michael, if I could just ask you to open the poll for this slide here as well. So we had some suggestions below. Now I think because I didn't tell Kahoot in time, you won't be able to select multiple answers. If we could just select the best option that you think would apply. So some suggestions that we had were to amend the deed to remove the appointer. We could appoint an appointer. We could just keep going with the company as trustee because nothing will happen. We could try to find the former accountant, or we could wind up the trust and start again. Okay, so I see about 10% of answers said to wind up the trust and start again. That is a good, clean way of solving the issue. But one of the considerations that we would make when doing that is who has the power to wind up the trust? And that's usually the trustee who has that power. And we don't currently have a properly appointed trustee at the moment. Also in this case here, one of the considerations that we have to give to is any stamp duty or CGT issues. And this trust actually held a number of properties in New South Wales. So the option to wind up and start again was a financial burden on the client. Appoint an appointor, we could do that. Unfortunately, there are no provisions in the trustee that allowed for an appointor to be appointed. And while it is tempting to just push along and keep going with the trust, if a dispute arises or if some sort of audit concern was raised, that could lead to more problems later on. And in this case here, a super fund held half of the units that were issued in this unit trust. So there might have been some audit concerns raised. In terms of the other two options that we've got, which is to amend the deed, to remove the office of the appointer, or to find Mr. Smith. Finding Mr. Smith is a good start, but what would you do after you found Mr. Smith? And you've also got the complexity of the fact that Mrs. Doe hasn't spoken to Mr. Smith for about 10 years now, and so she doesn't actually know where Mr. Smith is. And we can certainly amend the deed to remove the office of the appointor. The problem is, or hopefully if you answered that, you did ask yourself, who has the power to exercise the amendment clause? And if so, is a consent required? So let's just move on and I can tell you what our current plan is. Perfect. So our situation again, so we have Company A who can't exercise the power to amend the deed since that document 10 years ago was ineffective. The right parties did not exercise the power to amend, and yes, just did not exercise the power to amend. Mr. Smith can't be found. The client is still trying to find Mr. Smith, but once Mr. Smith is found, we do plan on amending the deed, having that signed by Mr. Smith, since he is the only person who's capable of exercising those powers. And at the same time, we'll rectify some other drafting issues that we found in the deed. Luckily, in this trust deed, no consent is required to amend the deed, so that was a lucky break. We'll also do a deed confirming the appointment of Company A and just ratifying those actions. But of course, that would also need to be signed by Mr. Smith as well, as being the only entity capable of doing the appointment once the appointer office is removed. Now, just going back there, if we went back 10 years, had Mr. Smith obtained a legal review on the document he ordered at the time, these drafting issues would have been picked up earlier, and these amendments could have been made while there was a properly appointed trustee. Because there was no legal review at that time, the client now has to channel her inner Sherlock Holmes and try to locate somebody who they haven't seen or spoken to in 10 years. And more importantly, the legal fees now trying to rectify that issue would have been avoided. So What role does an accountant play in engaging cloud-based legal review? So as I said earlier, accountants play a big role in recommending and engaging lawyers where necessary, especially when obtaining documents from a document provider. So accountants can provide a lot of information that ultimate clients may not have or may not know. Accountants are usually the first port of call when it comes to financial structures because clients see accountants at least yearly to do their tax returns, or to do trust distributions, or company solvency resolutions and things like that. So if an accountant wants to change trustees or transfer some units in a unit trust, clients usually think to see their accountants first. So accountants have a much more intimate knowledge of assets and sometimes client situations, as well as a working rapport with their clients. It's important to know what assets are held by the trust. That case study that we did just now is a really important consideration. The assets held was a really important consideration because obviously you want to avoid CGT and stamp duty issues. One of the biggest things that we need to look out for is where you're trying to change trustees and the trust holds real estate or other dutiable assets in New South Wales or the ACT, because if you don't do the right amendments, that transfer of the assets from the old trustee to the new trustee is liable to stamp duty at conveyancing rates, which can be quite hefty. A lot of ultimate clients don't really recall which assets are held by them personally or held by their trust or company. Some think that it's all theirs and it's all held in their name. So it's important that we get information from accountants in relation to where the assets are held. A knowledge of borrowings is important as well. Most third-party lenders do prohibit change of control of trusts and companies or amendments to trust deeds and constitutions if that third-party lender has loaned significant money to the trust or company. Sometimes the changes are allowed, but you need the consent of the bank. So it's important to have a think about that before changes are made. Sometimes, well, that's at least why we do that. We ask for what are the assets and the borrowings when we're asked to make amendments to a trust deed. Accountants can also initiate a cloud-based legal review if they've recently taken on a new client and received original trust deeds, and they want to ensure that the appointors and the trustees are appropriate and that appropriate provisions are in place for the succession of those officers of the appointor and trustee. Recently, we've had two matters where a former accountant was named as the alternate appointor. So if something happened to the appointor name, so the client, that prior accountant would have the power to change trustees. Now, I mean, it did result in these matters in a very uncomfortable position for the ultimate client because they had to go back and contact those prior accountants to see if they would sign documents to resign from that position. And had that former accountant said no, or if the client was too uncomfortable to have that conversation, then that ultimate client risks having to make an amendment to the trust deed that may not be completely effective and runs the risk, even if you do make that amendment, of having that prior accountant step up when the appointer dies, saying that, well, according to the trust deed, me, former accountant, is now the appointer. And they essentially would then have control of the trust. Now, I'm not suggesting that any accountant would do that, but that risk is there. The reason why there is a risk in making the amendment to the trust deed to remove the alternate appointer is because variations done by a trustee to remove appointers are usually prohibited, either implicitly or explicitly, due to that overarching role that an accountant, that an appointer plays. Okay, so I just need a very quick break. So if Michael, I could just ask you to open up for the final time, open up this poll, please. Okay, so now that I've gone through what a legal review is and I've gone through a few cases where things have gone wrong, what is your view of a legal review now?
Very interested to see these results, William, just to see how convincing your argument is.
Well, I think only about 1 or 2% wanted to see how persuasive I was. So I can't remember the percentage. I should have written it down. I had a pen here, but I see that about 55% now have changed their minds, or 55% are now saying that they'll use legal review when it's appropriate. And about 23% see that there are benefits, but need to know more information. And that more information we can deal with at the end of the webinar today. So what are some options to obtain legal review? So you can also, our first sort of option or first sort of solution is a combination of the first two solutions offered there. So you could use the cloud platform provider, obtain documents, and then take it to a third-party law firm. And when we say third-party law firm, we're talking a law firm that wasn't involved in the drafting of standardized templates. So the accountant could get a document from that cloud-based provider, and then the client would then take it to their own lawyers. Now, there may be some benefits to this method because your client may want to simply just get the base documents and have their lawyers amend it because they have a better working knowledge of the family situation, or the client prefers to deal with their lawyer face-to-face. However, some lawyers may not have the specific experience or haven't been exposed to that type of document that's being reviewed, and that could make that process expensive and time consuming. You then could have a solution where a cloud platform provider have legal review as a standard and have that sort of inclusive of the price. So that would be a good solution as you've got access to lawyers who have experience with trusts and companies and super funds and all those sorts of structures. But they would also have experience and knowledge of those standardized templates because they'd likely are the ones who have drafted it. One of the issues with that solution is that there wouldn't be a flexibility. So while as a lawyer, I would say you always need legal review, as I said earlier, I do appreciate that there are times where legal review is not necessary. For example, you may just want to simply incorporate a company and you wouldn't need a legal review for that, except of course when you need amendments made to the Constitution, for example, to restrict who can be shareholders and directors if that company was later going to apply for registration as a pharmacy business. You then have the last solution that's here on the slide there, where some cloud platform providers offer optional legal review. So you still have the access to lawyers who have experience with this area of the law, and you also have access to those lawyers who have the experience and the knowledge of those standardized templates offered by that platform. The difference between this solution and the prior one is that you do get some flexibility and you do get to choose which documents you're obtaining will undergo those legal review. One of the downsides of using these sorts of platforms is that there may be different level of reviews available, and those different options could be overwhelming. And there's also an unknown factor because you don't know if the legal provider will agree with what you consider as a simple matter or what you might consider as a very difficult matter. You may not get the legal providers agreeing with you. So it is up to you as to which option you take, even if you do take an option, because some factors may appeal to you more than others. I do know that we are quickly running out of time, so I'll just leave this slide up here for a few moments. So a quick checklist of some points, and again, these checklists are subjective. Some of these factors may appeal to you more than others. So we may be looking at things like optional add-ons might be something that you're looking for because you want that flexibility. You may prefer having a one price suits all, so you don't have to go back to your client and say, well, I want to get a legal review on this and that's going to cost an extra X amount of dollars. Or you may prefer to have a written audit trail so that you can show that if something goes wrong, that there was a lawyer involved, and then you can go back and you can say that they've done something wrong. So just an industry example that we've got here. As we're partnered with NowInfinity, we are involved in their optional legal review that is offered. I'll quickly let any attendees who are interested just to have a quick look at this, and I might just ask Kristen if there's just any questions there that have come up recently that I can deal with.
Not at the moment, but I did have one while everyone's
Sure.
having a think about all the information, because it's obviously quite a lot to digest in 48 minutes. So I'll just, while everyone's doing that, and I just wanted to ask about digital signatures, which has now been quite topical of late, and whether or not it's now legal to use digital signatures.
Yeah, so it's a good question, and unfortunately, I'm going to give you the lawyer spiel on this and say, look, there are many different answers because it does actually depend on very different factors. For example, is it a company that's signing or is it an individual that's signing? It also affects the document that's being signed and whether a witness is required. And especially with individuals, that place where they are signing is actually important as well. So for companies, we all know, or we all know that there is temporary legislation because of COVID introduced, but there are some restrictive requirements. If you have a look at section 127 subsection 3B, it sets out, of the Corporations Act, it does set out certain restrictions and requirements that you need to meet for companies to sign electronically. So I think I've just got a copy here. So a method must be used to identify the person and to indicate that person's intention to sign the document, or a counterpart or a copy of that document. And if a counterpart or copy is used, then the directors of this company would need to ensure that the entire contents and any other counterparts or copies signed are replicated exactly. And you also have to ensure that you use a method that is, and I'll quote these words, as reliable as appropriate for the purpose for which the document was generated or communicated. Now, to me, that seems to mean that, taking a photo or taking a scan of a signature and using that image and copying and pasting that on a PDF might not be a reliable method when you're signing a deed or if that company is dealing with properties. But it might be okay if the directors were signing a letter to internal employees, or it might be okay if they were just signing a contract, a low-level contract with employees. There are some online signature platforms that could satisfy these provisions. However, legislation is quite neutral, or is neutral on what type of platform you could use. And I just see Z's just asked a question here, whether documents via DocuSign would be acceptable more than signing, scanning, emailing way. Look, I haven't actually used DocuSign and seen the methods required to sign that. And for companies, it may be okay, because if I remember the way that DocuSign works, it does give you a page at the back that shows you who logged in and who witnessed, who signed in and who essentially signed the document. But you would need to check whether or not it meets the rest of Section 127. Just to go to the other end of the spectrum, if there were any individuals who were signing a deed in Western Australia, they actually aren't allowed to sign deeds electronically, because Section 9 of their Property Law Act says that all deeds must be physically created, signed and witnessed, and you can't meet the physically created sort of requirement if it's only on a digital sort of hard drive. Kristen, we could dedicate a whole webinar to digital signatures because of just all the different complexities. But to quickly just answer that question, in short, yes, except of course if you're an individual signing in Western Australia. But, and you know that but's coming because I'm a lawyer, you need to be wary that you're complying with those restrictions that are imposed. And certainly if there are individuals signing, you would have to check the individual legislation in each state or territory.
Thank you. If anyone has any other questions, please pop them in the chat while we wait, because we still have a few more minutes before we need to wrap up. William, is there, just flowing on from your case study before about the Mrs. Doe who couldn't find her accountant, Mr. Smith. You know, would you say that it's, you know, what sort of advice would you give to our members on becoming that involved at that level with their clients? Is it something you've got a strong opinion on?
Well, it's ultimately up to your members whether or not they take on those roles, but it's important to remember that, you know, if for any reason that your client leaves the firm, there is a handover of sorts. And I did mention those other two sort of matters that we're currently dealing with, where a former accountant had been appointed to that alternate appointable role. And, you know, a legal review might not have dealt with that, but, you know, if they had other changes done earlier, it was actually interesting because in that I was like, oh, who's this person? I never heard of his name. You know, they're not directors of the trustee company, and no idea. And we finally, when we asked our client, they went, oh yeah, that was a former accountant. We got all these documents from them. And so yeah, look, it is potential. I mean, you could do that. I mean, solicitors sometimes act as executors of estates, you know, for clients where they just don't have anybody else to act, or there might be some family sort of issues, and so they want to keep that, you know, an independent person appointed, just to avoid any conflicts. So it may be a situation, but I would always get a client's authority in writing to better protect yourself there.
We might have a few members thinking about some clients right now that have sort of those older trustees lying around, and whether or not there's an appointer named in there, whether or not it's them.
Yes.
So Well, thank you for your time. We haven't had any more questions come through, so you've obviously covered the topic very well, which is excellent. So thank you very much. Thank you to everyone who attended today. William, was there anything that you wanted to add just before we hand back to Michael?
Yep, if anybody did actually think of some questions after we leave today, there probably was on the last slide there, just a way to reach out to us, just a proper channel to reach out to us if you did come up with something afterwards, or you're starting to think about some bold trustees where the member might be appointed as an alternate appointer, and you might need some amendments made. I don't know if these slides are going to be made available, but there's an email address and some phone numbers on the last slide there.
Thank you.
I'm just bringing that slide up for you there, William. It's coming up now.
Thanks, Michael.
Thank you. I have no further questions and nothing else has come in. So thank you very much again, and thank you, Michael.
So I'll just
excellent. Thank you very much. I'd like to thank a huge thank you to the panel for a fantastic webinar today. Thank you everyone for your participation, for your attendance today. If anyone has any last-minute questions, please pop it into the chat box now. However, if you're ready to leave us now, that does conclude today's webinar. To exit, please click on the X in the bottom right-hand corner of the panel. As you exit, you'll be directed to a feedback form, which only takes about 30 seconds to complete. Feedback is really beneficial to CPA Australia as well as the panel. We sit and review your feedback, so it would be really appreciated if you could take the time to do this. Just to let you know, everyone will receive a copy of today's webinar recording. This will be sent to you via email within the next 24 hours. Thanks again, everyone. I can ask the panel to switch off their webcams now and stop their videos. Enjoy the rest of the day. We look forward to seeing you next time. Take care.